Hey everybody, welcome. Finally, here we go. 12 p.m. Eastern. Welcome to the Entrepreneurial Strategy Series. We call it ESS, the last Thursday of every month. Hey, Frankie Fox, good to see you. The last Thursday of every month at 12 p.m. Eastern. And we're super excited for this topic. It's been a natural outgrowth. Me being a patent attorney, you can't not talk about trade secrets. And so we are going to learn all about that interplay. I am super excited to have these two ladies on the panel. I've known them each for many, many years. My introduction cannot do them justice, except that I love them dearly and think they're just amazing in every sort of way, and have helped many, many clients over the years. And I'm excited for all of you to meet them. So I'm going to ask them to introduce themselves as little or as much as they want. First, now it's just about the introduction. But we'll start with Nicole Galley. Let us, please, the floor is completely yours.
Thanks, David. I'm real excited to be here. I was also really excited to meet my co-panelist, having heard many things, good things about her for years and years, but hadn't had a chance to meet. So I'm Nicole Galley. I'm a U.S. attorney, admitted in a number of jurisdictions here. I've been practicing for 3 decades. Started out my practice as a patent litigator, predominantly, although I've always done other forms of commercial and IP litigation. So I definitely am someone, although not a patent attorney, I'm someone who comes at trade secrets from a technical perspective, from a perspective that has a lot of respect for patents. And I would say that about 10 to 15 years ago, I started to get more involved in trade secret cases, more involved in complex trade secret cases, and really became intrigued and interested. I mean, obviously, it's something we all knew about for many years in the law, but really became very intrigued by a lot of the advantages and perhaps some disadvantages that you encounter. And we'll talk about some of those today with trade secrets. And realized that there were a lot of unanswered legal questions, and also that there were a lot of things that companies were not doing, especially at that time, to be proactive in protecting their trade secrets. And spent many years since then looking at that issue. I worked on several best practice initiatives here in the US. One is an ANSI standard that you can actually go and buy a copy of, that was issued by the Licensing Executive Society. It says it's IP, but it's really about trade secrets. It's a system for trade secret management that you can actually use within your own company or as an assessment tool for suppliers that you're working with, because it really was focused on supply chain issues. It's just a maturity model, a way to kind of assess things. And then in addition, through another organization, the Sedona Conference Working Group on Trade Secrets, it's a think tank basically of attorneys in the US from all different perspectives, where we spend a ridiculous amount of time talking about the intricacies of trade secrets. But that's another thing you can actually go download from the Sedona Conference. It's a many-page tome on best practices for trade secret protection, or, well, we didn't like to call it best practices, but practices for trade secret protection. And then, ever since then, litigated more and more. My practice is more heavily focused on the litigation of trade secrets as well. And I'm currently involved, last little bit of intro, in another project now with Sedona, drafting jury instructions for first model set of jury instructions ever, comprehensive one that was done not in a specific jurisdiction in the US, but nationally, for the Defend Trade Secrets Act, which is the federal trade secret law that went into effect in 2016. So it's an exciting field to be in as an attorney. Lots of challenges, both for businesses and lawyers when it comes to trade secrets, and I'm thrilled to be here today.
Amazing. Thank you, Nicole. Can you share, if you can share some of those links if you have
Oh
them?
my gosh. Can I do
Well, no,
that later?
don't worry about it. We
I'll
can
try to
definitely
go
do that
find them.
later. So after this presentation, just FYI to everyone, we will send out like a recap. We and the actual video. And so maybe in that recap we can include those links. That would be
Yeah, that would be great because I'll
okay.
sit here poking around and lose track.
No. So stay on track for sure. Elanit Appelfeld, welcome. How are you? How's it going? Introduce yourself. Let everybody know who you are. I'm going to ask you to unmute.
Thank
Go.
you, David. Hello, everyone. As you may know, I'm based in Israel, so a little bit. I'm in Athens right now, but we're all a little bit shocked from the event. Actually, a lot shocked, and it was a really nice invitation to come here today and talk about happier things. And of course, we stand with Israel, and really happy to be here. Thank you, David. Good to see you, Nicole. Um, Hi, Mary. You can't talk about trade secrets and trade secrets insurance without seeing Mary. So good to see you. So a little bit about myself. I work with technology companies, startups in all stages from seed to post A, who want to protect their technology and whether they're on the road to find product market fit or they need investors to help them get there. I help them, identify their intellectual property, basically know what they have, and communicate it to their investors, but more importantly, of course, protect their secret sauce. And as Nicole said, Nicole realized the shift a few years ago. I think Nicole, you said 10 years ago. Then for me, my journey with trade secrets, and trade secrets is maybe one step back in Israel, but we see a shift happening in the intellectual property world. We see companies realizing that patent is not the only form of IP, and we see companies approaching investors, and we see companies approaching innovation authorities, and we see funders saying, "Hold on, what's your intellectual property?" And we see funders and investors asking, "Okay, we see your patents, but how are you protecting your intellectual property? What are your processes?" So we see a shift. We see company acquired, and we see the due diligence stages, and we see that investors are looking at things differently, and we also see, just to give an example, a lot of companies in Israel are seeing now that maybe they should look at their companies differently, especially when they're dealing with software and SaaS companies, and they know what their advantage is, and generative AI. Patents is not always the right answer. So what I do is I help companies articulate their IP and present it to the investors. And I've researched the challenges of startups, and I developed some practical solutions. And a very big part of it is around trade secrets. So hopefully my aim here is to, simplify the way we look at trade secrets. And I hope Nicole will give the more advanced perspective of, what happens when it gets to litigation. But I think I'm a step, how do we define, how do we identify the trade secrets that we have, and basically how we present it to partners, to investors, etc.
Thank you, Elaine. And so just so everybody understands, you are a patent attorney as well.
So I'm an intellectual property attorney. I have an LLM in intellectual property. I don't draft patents. I'm more the transactional licensing side, and I'm an IP manager. So I do all the strategic thinking about how to plan the IP, where to file it, all that strategic thing around how to manage the company how to manage the IP in companies. So we help companies prepare for the due diligence. We help them create trade secret protection plans, and we do it. We try to simplify things as much as possible.
Okay, so let's get into it. Normally when I give a presentation on intellectual property, as a patent attorney, I'm always, a patent, trademark, copyright, and I normally introduce trade secret as like the stepchild or, oh, that fourth form of intellectual property. But I think this presentation is meant to, really delve into that. So I want kind of each of you, if you can, Eleni, maybe we'll start with you if you want, to kind of just give us, just for the sake of the audience here, what is a trade secret? What is it
Okay.
exactly? What are we
Okay,
talking?
so I think the worst thing is to start with a actual legal definition. And the best thing is to start with a story, because stories I always get things really quickly with stories, right? So the story that I thought of telling you today, I mean, we could have chose any business, but I thought of taking a story about a restaurant owner who was very known. He was well known for his taco recipe. Let's call him Raul, okay? And Raul runs a famous and successful restaurant, and people come from all over the world to taste the taco. And he was even approached by a multinational food company that wanted to cut a deal and buy a license to sell the frozen meals based on his recipe. And as often happens, one of the restaurant's cooks decides to quit and opens a new competing business next, on the other side of the street. And the new restaurant also serves taco, which is, surprisingly similar to Raul's taco. And naturally, Raul becomes very upset and he sues his former cook. And he claims that the former cook took his recipe, which was a trade secret, and he stole his trade secret. And when his potential distributor hears about this, the big deal, it doesn't happen, it's derailed. And when Raul sues his cook, he loses against that cook who took the recipe. Now, why did he lose? He lost because he didn't write down the recipe, and he didn't explain to his employees just how valuable the recipe was. And he didn't tell his employees that they were expected not to use the recipe in any way outside the company. Okay, now, why did I choose this story about this restaurant and not a story about a company with, technology, software, Tesla? So I chose this for many reasons. When you think of a small restaurant, you don't immediately think trade secrets or IP. And this story shows that any type of business can own very valuable information. Also, it shows that trade secrets can be any type of valuable information. I mean, not just a recipe, can be a supplier list, can be a process, can be anything that you do that gives you an advantage if you document it and protect it. And I think this story also shows that companies just don't do enough to protect their valuable information, even when it's clear that they have an advantage. And it also shows that when it comes to trade secrets, the biggest risk comes from the closest people who have access to a trade secret. Usually it's employees and contractors. So I find this example easier to explain, to explain what a trade secret is, because it's easy to explain the value of a simple taco recipe created by an experienced chef than it is to explain why an algorithm or process behind a software is so valuable. And maybe it's easier to see the critical need to protect an asset such as simple as a taco recipe when preparing for a large deal of to distribute frozen foods than it is to see how an algorithm protection is relevant to preparing for an exit. So I hope this story gives you kind of a understanding, like anything in your business can be a trade secret. Nicole, anything to add to it?
Yeah, well, I just want to say very quickly, we love food, we love tacos, so awesome example. But yes, Nicole, what do you think?
Yeah, absolutely. I mean, I agree with everything that you just said. I would say the one place where, and I don't know if this is a difference in the law, the only thing that I would have a little different view in what you said, which I'll touch on first and then come back to sort of bigger picture, is here, while it's considered to be helpful, a good idea, quite honestly, in my view, a best practice to document your trade secrets, that's still not required under US law at all. It is not always that feasible. And I've seen people actually, and this is one of the big concerns from a litigation perspective, I have seen cases where people run into trouble with documenting, but not fully. And what does your document say? So,
Right.
so whether or not to document is not a step to be taken lightly. But it's absolutely something you should think about and potentially do, right? Like if you have some particularly crown jewel value, or if you're going, and I'm sure Mary would tell us this, for insurance, or if you're going for investment, or frankly, if you're going to be sharing information in joint ventures, you touched on employees and contractors. That is 100% true. More than 90% of trade secret theft is from what we would call an insider, which is typically employers or contractors, but also joint ventures. And that's where some of the most challenging and difficult cases, and that could mean anything. It could be supplier customer. It's often small company versus big company. It could be literally two partners. So when someone I know in the trade secret bar talked about exit points. Whenever there's an exit point, an employee leaving, a contractor being done, you're sharing information with a prospective investor. You're sharing information, with other companies. When you're getting outside the walls of your company for any reason, which is really all the time if you think about employees, you really need to be clear, at least at a high level, about what needs to be protected. But the reason why it gets complicated and why it's not easy to do that, and that's where I kind of want to take a step back, is I have an even broader view of trade secrets. And in this country, there's a lack of agreement right now within the trade secret bar as to whether or not there is a distinction between simple confidential information and trade secrets. That would be a whole discussion in and of itself. But it really could be anything. The definition, at least in the US, it's a very simple definition for law. Anything of value to a company, competitive value to a company that is maintained as a secret. I mean, think about it. It's anything. And the restaurant, I actually think, is a more obvious example with a recipe. I like to give examples that are totally not technical. So if you think of coaches, lawyers, business advisors, you have trade secrets. You have ways that you are doing your work that are unique. It's what is giving you your competitive edge. And even if you have patents, and this is something, every patent is a trade secret. Started out as a trade secret and then grew up to be a patent. It was a trade secret till it was published. And in my experience as a patent litigator, every single patent case, there are lots of trade secrets that go along with it. How do I know that? Because we fight tooth and nail in every case I have over a protective order that is going to be governing the protection of confidential information and trade secret information of our clients within that litigation, especially if they're dealing with a competitor. And we have something called a prosecution bar, for example, where if you're going to learn things in a litigation, because of litigation, even as a lawyer, you can't therefore be prosecuting patents knowing that information for a competitor. So they're everywhere. And really they go back, I mean, there isn't consensus about when they started, but I can tell you it was before patents. There's no question. Some say it was the Romans. There's some examples from Turkey. There's definitely the guilds in the Middle Ages. There are situations where they didn't let people off the island. That is a literal true story because they might take the trade secrets with them. I mean, this is going on since the beginning of time. I mean, think about it. You have a secret way of doing something and you're going to not share it with anybody because you found out something terrific. That's a trade secret. And you've been doing that since the beginning. So it becomes overwhelming if you think of it that way. So what I usually say to clients who come to me is a trade secret that is important to you anyway. Some are more important than others. They're all important in context, but things that you should worry about, particularly being focused on, are those things that you'll actually pay somebody like me, pay a litigator to go get back or to stop somebody from using. If nothing else, that right there is the thing that's most important. Is that your process for making something? Is it your secret way of doing something? Is it your customer information? Is it your strategic marketing plan for a new opportunity? Could be anything. So when you see that, you're immediately overwhelmed. At least I think most of my clients are like, oh my gosh, how do I do this? Well, you do this every day, right? And you do this every day. Could it be done better? 100%. And I agree with everything that was said about how it's becoming more important. We've seen this in the US over the last 10 years. I think it was really going even further back. There have been, and there's a lot of studies that have been done here and in Europe showing the value of trade secrets to companies. But here, there have also been studies as recently as 5-6 years ago showing that even of large multinational companies, maybe 30% at that time had robust trade secret protection programs. Didn't have lawyers in the company, even if they had big law departments who were dedicated to trade secret protection. So it's really starting to become more important for lots of different reasons. I think because of technology shifts. So AI is a perfect example. Here in the US, it's also as, software and business method patents have become more and more and more under attack. I think that was really probably the final straw here to, once, as we call it, the Alice decision for the patent attorneys on the phone. Once software eligibility became really difficult to get and maintain software patents, to me, that's when people were suddenly like, wait, we got to find something else, right? And what are we going to do here? So they've always been there. They're everywhere. They're not just technical. And the thing is, if you don't protect them, you lose them. Now, there was a question in the Ireland about 700. Yeah, I mean, I think it's go back to like the Stone Age, right? Like the person who was chipping away at something and figured out a great way to break something apart. I mean, it goes way back. I want to pick up on the question about US patents are not protected overseas and how do we protect trade secrets that come out of the US? The answer is the good news is it doesn't matter, right? Like it's not really something you have to worry about geography. You may have, in a sense, you may have protection with an important but, right? If someone's coming into the US and working with you in the US and getting your information here, then you may have more substantial protection over what happens outside. And it's even if they go back to their home country and start to use it. And there is some cases here in the US that do have some extraterritorial implications. The tricky part is it does become difficult in certain countries. And I know multinational corporations, for example, who are operating and maybe even manufacturing in lots of different countries outside the US, really worry about this issue because not every country recognizes trade secrets or not to the same degree. For example, they may require documentation. And if you don't have a document, then you don't have it. Or even if there's theoretically laws on the books, they may not be, that good. So in those scenarios, though, you do have ways to protect yourself. You think about, what do I really need to reveal? Can I put something in a black box? Can I keep some, but it's not perfect. I mean, it's definitely not perfect. So it's easier in some ways. You don't have to go file in lots of different countries, but it's more difficult. And if you have something that is capable of being patented, then and you're in a country that maybe doesn't have the same trade secret protections, or really even if you are, there are oftentimes benefits to get that, to say, maybe I don't want to keep this as a trade secret, even though I could. One of them is the international issues, and the other is that you can't stop people from coming up with it on their own, right? So it's only if people take it from you that it's a problem. But if someone comes up with the exact same thing that you have, even if you've had it for years as a trade secret, that's fair game, right? And that's a place where patents help tremendously. And that's why you have them. And that's why you ideally need both. So that was a piece of it.
Agreed. David, you're muted.
I was going to say, thanks, Nicole. You touched on a lot of good topics to jump off of. Eleni, do you want to kind of jump on some of them?
I think that my perspective is a little bit different than Nicole, in a sense that we have that in the technology, and this all these exit points. We see one of the biggest problems that we see is companies who they're developing a lot of tech. They have employees onboarding and offboarding, and they have a lot of they need to know what their IP is. And I want to give an example of something that we've done with a client that said to us, listen, we're developing a very interesting technology. We want to be acquired, but we don't know, we don't know what we have. We don't know. I mean, I go to sleep at night and I'm thinking, if this employee left, I'm in trouble. I have 4 employees that if they leave the company, I don't know what to do. Can you help me? Now, so, and he said, and there's something that Nicole said, it's something that you do every day. But, when a company that has been developing a product for 3 years suddenly starts to think, hold on, what happens if my key employees leave? Then they need to kind of start somewhere. And that somewhere can be overwhelming. So we go on a call with the let's call them key developers or the founders, if the founders are technical, and we do some kind of interview. We do a technical interview, we do an audit, and then we ask a few questions, and we kind of help them put a different spectacles. Let's look at what you do a little differently. And they may think, a trade secret is only if we have this crazy method, it's an algorithm, it has to be very, very unique. And when you sit down with them and you tell them, oh, really? How do you do that? Oh, well, we have this method that we know who are the specific suppliers for the specific thing, that if we order it through these suppliers, we cut the delivery time in 50%. They would never think that is a crazy trade secret, but that gives them an advantage over their competitors. And suddenly they realize, hold on, who knows about this? Oh, really? The admin knows about this? Oh, maybe admin should know that when the company does stuff on LinkedIn, they should not post it on LinkedIn because this information is sensitive. Okay, so this is an example. We look at the activity, we do the audit, we see there's technical trade secrets, there's marketing related trade secrets, there's my go-to-market strategy is a trade secret. I agree with Nicole that not everything needs to be documented, but maybe in the startup world where you kind of need to prove your trade secrets, and you at least a high level definition and awareness of my employees knowing what the sensitive information is, goes a very long way. And with our experience, companies who start having these conversations, suddenly they understand, suddenly they get it, and they say, we're having this chat over lunch, and suddenly we realize that this and this are trade secrets, and we should really treat them differently. So it's like you have to put your hands in start working to see how it relates to you as a company, or even as an investor who looks at the company and wants to know, wait a minute, what does this company have? Okay, they have patents, nice, but maybe maybe the real advantage is not in the patents. We filed the patents because they prove that we're innovative, and we have this inventive step and all that. But this team of developers has a lot of know-how, and investors want to know about this know-how. So when we work with companies, it's just nice to see that shift in the way they see things, and suddenly they can run on autopilot, and they recognize the potential trade secrets in their business.
Eleni, you actually bring up a good point, because I think most companies, big or small, don't realize that if there's one break in the chain of the secret, that it's probably not going to be enforced as a secret if somebody possibly stole it from you. So to that point where you're educating the company, I get that. That's a great step. You got to educate them because there are people down the line that just have no clue, right? They just have no clue as to what even a patent is, let alone a trade secret. What else mechanically is needed? Like, it's not just, okay, we won't talk, we won't post, whatever, but like mechanically, what is needed within an organization? I think Nicole will probably have some thoughts on this too, but we'll start with you. What else is needed to keep something a secret? Because as we all know, to keep something a secret in this world where we vomit everything about everything on social media and everything, like, how do we really mechanically keep something secret?
Okay, so starting from the basic, very basic example of what a company can do, then there is an internal policy, all right? So it's like a set of rules, what the company does to protect its information. So there are stuff that you may want to document, and there are stuff that maybe you don't want to document. But in relation to what you do with a trade secret, first of all, you start training the people in the company to understand what it means to have a trade secret. Okay, so we have the confidentiality agreements with third parties that we can use whenever we share sensitive information. But if we start from the company itself, then we would be looking at, let's see who's exposed to the trade secret. We want only the people who need to know about the trade secret to have access to it. So for several companies, we do we manage the trade secrets in a way that not everyone has access to the trade secret. And then we have we restrict the access, and then whether we document or not document them, we have this policy that for example, if a guest comes to the company, we don't want him to be aware of things that are happening in the company that may hint of what the trade secrets are. For example, another story, okay? Some of the best practices relate to employees. So we want the employees to have an idea of what the company treats as a trade secrets, okay? So sometimes we have a call at the middle of the night saying, the CTO calls us, he says, we found that one of our people in the company has sent a huge amount of data to his personal Gmail account with a lot of stuff he's been working on, and we don't know what to do. What did he send? Usually, it happens when an employee sends stuff over to their Gmail account because they're looking for a new job. So if my employees as a technology company have this training, the basic training of what the company sees as sensitive, or even without getting into the what the company sees as trade secret, but just to understand that not all information in the company is treated the same. So all this training stuff going on in companies makes a huge difference from when an employee comes to my company from a third-party company, and I want to make sure that he doesn't bring other people's trade secret, and I want to tell him or her, listen, you're coming into my company, please don't bring third-party material into the company. And then after that training, depending on the classes of trade secrets, you kind of do a set of rules for the company to follow. So how do I restrict access? How do I communicate what the trade secrets are? What do my salespeople tell? When we get phone calls, we had a phone call from someone, from a CEO, said, we had a sales call. It was a fantastic sales call, but we just realized that it was a competitor who did the sales call, and my sales rep just gave a lot of information, and we don't know what to do. And I don't know how it happened, but it was an hour call, and we recorded it. Then the more we listened to the call, the more we realized it was, trade secret theft. So it happens like the taco recipe example. I think that once you define the set of rules in the company, how you share the information with the outside world, when do you need a confidentiality agreement, what it has to say, how do you train your employees, how do you onboard, how do you offboard, how do you tell an employee when he leaves the company how he should behave without threatening and without warning. And at least for Israel, we have the law is very pro employee who leaves. We have the freedom of labor, freedom of profession. You can't really limit the freedom to work and to use information. So you need to be very, very sensitive about how you treat the whole thing. So you come to the employee training. So I find that the trade secret protection plan should really, it's like a set of rules that if it's followed, it's if it's in the awareness and if someone is responsible for it, it just becomes part of the DNA of the company. And I think it's manageable, by the way. I don't find it overwhelming. I mean, obviously I don't find it overwhelming, but I think that a company that adopts it and does a step at a time can reach a very high level of trade secret protection.
Awesome. Thank you. Nicole, what do you think from a kind of mechanics perspective?
Yeah,
What do the company need to do?
so I did dig up the two
Oh, I saw
links to
that.
the two things. I popped them in the chat. One is free, the Sedona one, but they do require that you register and provide an email address. And then the other one is, I think, like $100 or something. But to kind of like take maybe up a little bit of a level from where we were, which is so I agree with everything. So much of what was said is so consistent with things I would say. One thing I would keep in mind to start is what are the requirements, and this is where speaking with an attorney in your jurisdiction is really important, because even within the US, there are differences in the law, right? Because in the US, we have a federal law now since 2016 that protects trade secrets. But historically, and still, every single state in the US has their own law, and it's not all the same. And so that one of the things that really varies, and to touch on what was just mentioned, is whether or not we can use non-competes or even any type of a restrictive covenant. We have different kinds. Restrictive covenants means non-compete, gardening leave, that sort of thing in other countries, where you can't go work in a competitive position at a competitor, narrowly defined as to what's a competitor, what's the geography, what's the duration, but for a period of time. That's a non-compete. Some jurisdictions here, like California, absolutely banned. Others are starting to ban it. Non-solicit. You can go work for the competitor, but you may not solicit your customers for a period of time. You may not solicit other employees for a period of time. Some go so far as to say you can't accept business from the customers, even if they come to you. Again, a lot of jurisdictions here do not recognize those. And then even a confidentiality agreement, believe it or not, is considered a restrictive covenant. And so one of the things you're starting to see here in the US is you got to be really careful with those. You can have them, but if you're having them with your employees, and even generally, they non-disclosure agreements or confidentiality agreements or clauses of that in other contracts used to be a throwaway, right? Everyone's like, everything's confidential and you got to keep it forever. And, sometimes too, what we see here too is a lot of times private equity companies or investors don't want to sign them because they don't want to be hampered and have all these restrictions. And they say things like, don't tell me your trade secrets. Oh yeah, I'm trying to get investment. I'm not going to tell you my trade secrets. It's ludicrous. But they used to be not really that important. And what we're finding is that if they're not done properly for your particular jurisdiction, they can actually backfire and really bite you in the bum. And one of the things I've seen recently is not just one, but multiple confidentiality agreements that were reviewed by lawyers, not in my firm, that have termination clauses. Now, that's fine as to some of the obligations, but they didn't have the most essential from a trade secret perspective. They didn't carve out trade secrets. what it should say is, our agreement is for X period of time. And your obligations generally terminate, except that your obligations as to confidentiality, as to trade secrets, continue forever as long as those things are actually trade secret. I mean, that's what you need. It's very simple. It's not hard. But I've seen several agreements, and that's been a problem because there are some jurisdictions here that say that means it was never a trade secret in the first place, which I disagree with. But it certainly makes it harder. So the issue of what should you do, it's a question of what do you have to do in your jurisdiction, what's available to you. And then if you don't do it right, it can actually be worse. And I've even seen that. I used to be 100% a proponent of inventory or trade secrets, write stuff down. Unfortunately, I have seen where that's not done properly. I know of some really sad cases where it's turned around and really actually bitten people in the butt. Like it's been a problem where they missed something, they didn't describe something well enough. Where, for example, if you have a really draconian policy that says every single document that relates to a trade secret or confidential information is going to have the legend confidential, well, then what do you do if it doesn't? Or what do you do if it over designates? So I 100% agree. And that's why I spent many years, literally years, working on these two different documents that provide some guidance on how to set up a management system. But you really need to be thoughtful. You really need to think about what can you actually maintain, because that's where people run into the most difficulty, and you have to train people. I can't underscore enough that if you're going to put a system into place, it needs to be frictionless, because people will work around it if it's not. So you can't have it be aspirational. So what do you need to think of? The very first thing is you need to think about, as was said, you need to think about what are your trade secrets? What are you going to try to maintain confidentially? And 100%, no client really knows until they start talking to someone who knows trade secrets, because they're thinking it's the Coke formula. It's not something like the secret vendor that is hard to find. The other thing is trade secrets, at least here, it could be what didn't work. On manufacturing lines, I love process trade secrets because it could be the order in which the equipment works on the line. It could be anything, but you need to think about it. And someone who is being intentional and who has the strategic view needs to be the one thinking about it. Because the other thing I say to clients is, let's not make any mistake. People are making decisions in your company every single day about what they think is confidential and what they think is a trade secret and what isn't. How do we know that? Because if they're a coder, they may be posting a snippet of code onto some coding listserv for if they're struggling to do something right. That's very common. Here, I'm having trouble figuring out how to code this particular thing. Anybody has ideas? So if you're, so why not have the people who actually have the big view, have the strategic view, make those decisions? And then it is a lot about education. It's a lot about training. And it's a lot about working with the systems you already have and adapting them to this. What do I mean by that? Obviously contracts, and don't put things in contracts you're not going to do. Like if you say, I'm going to go get the mold back from the manufacturer, in whatever country, you better go get the damn mold back, right? People don't. People leave the molds, even big companies. And then it's like, oh, why do I have gray market goods? Well, think about that. So make sure that whatever you're putting into your agreements, that you actually know what they say. Another thing we see in supply chains, and this is true at small companies don't sign things you can't do. And big companies, don't ask your suppliers to do things that they just simply can't do. You need to go see, can they really meet what you've demanded? And then check on it. So it doesn't work to put things into place that are just not going to be manageable. So you really need to think about, what are you doing already? What can you leverage? A lot of cybersecurity is very helpful. But again, only a small percentage of trade secret misappropriation is from strangers. It makes the news here in the US, certainly, but you still need it, but it's not the end all and be all. So great, you have stuff on a laptop, you have to have a password, you have to have encrypted, but somebody goes and leaves the laptop somewhere, people can break through things. Their password is welcome one. I mean, come on. So you really need to think through all those things. Again, training is really important. Policies are important, but again, you don't want to have the world's best policy only to not use it. And, again, think about, is it really realistic to maintain this, whatever it is a trade secret? Can someone reverse engineer it? Is it so intertwined with ordinary skill and knowledge that when workers leave, there isn't a whole lot we can do? And then I also, in some industries, like I know semiconductor, the concern is more on the inbound, right? So that's the other thing you need to be concerned about too when you're hiring, or working with a vendor or working with a contractor. You need to be sure that you're not getting other people's trade secrets. So that should be part of your process as well. So, I mean, literally, I have spent years, and we could go on ad nauseum about all the various things you should and could do. Here, the nice thing in the US is it's reasonable. It's a standard of reasonableness. You need to take reasonable measures, and that's going to vary. Size of the company, type of trade secret, where you're located. It's not perfection. I wouldn't have a job as a litigator if it were perfection. It's reasonable measures. And one of the things that makes that so hard is it really is situation dependent. So I can't answer, do you need to have a trade secret policy? Probably. Does it need to be formal, written, extensive? If it's you and one other person, I don't know. Do you need it? Maybe you do. I don't know the other person in your partnership. Maybe they're not, maybe you need to like write it down so you can be like, hey, go do that. Should you have to, have specific trade secret clauses in the NDAs? Yes, we talked about that. You really want to be clear that you're protecting those well. Do you have to tell the partner what is a trade secret? Can't hurt, but don't box yourself in either. Because if one of your engineers doesn't do it, you want to give yourself wiggle room. As the litigator in the room, don't make that job harder later on. Always make sure there's wiggle room. I've seen some things that don't. Don't use ChatGPT. That's my PSA.
Agreed with
It's
that.
got all kinds of problems. I'm probably, on the wrong end of that. There are others who love AI, and certain AI is great. But again, it's very situational. Like Mary was saying in her comments, which were fabulous in the chat. If you're going for insurance, if you're going for investment, then it's not what is reasonable for enforcement. It's what's going to get you the money, what's going to get you the insurance. And that's a whole other level to consider. So
I love that. That's a lot. Great, Nicole. Eleni, did you want to add anything?
Just about the investors that we have experience with investors that look at companies and they say, how are you protecting your IP? And then, some companies say, we have one client that David, you know of in the branding way, that they developed this secret formula of this vegan gluten-free hamburger. And the investors were saying, what's the IP? And we advised against patents. And, the founder said, with all the confidence in the world, it's a trade secret. And they said, okay, what's the trade secret? He said, well, I can't tell you what the trade secret is. That's the company policy. They ended up investing. And it's a great story because sometimes, the investor needs to feel comfortable that you know what you're doing. And you need to talk confidently about what you're doing and how, and Nicole touched on what's not working is huge. Once we were working with this company who wanted funding from the European Innovation Authority. And we just prepared the IP story for, the IP description of what the company had. And we just told the story. And after years of failed results, after years of failed attempts to do something, the founder found out that doing it a different, non-intuitive way is going to do it. And, when he was asked, how are you going to make sure that you're not copied? He said, well, they would have to go through all my failed attempts to know how I got to where I was. So a big part of it when money is on the table and you want to present your IP is to talk about, describe your IP story and talk about your trade secrets and the way that you got there.
Yeah.
So that's the big thing that's working.
I love that. Yes, Nicole, please.
Yeah, two things I'd like to add, picking up from that. One of the other things that I think people still are not focusing enough on, even though there is more of a focus on the kinds of things we've been talking about, like identifying the trade secrets, making sure you have a good management plan for them, et cetera. One of the areas I feel like people also need to really focus on is thinking ahead, again, from a litigation perspective. And this does come in even to the investment and valuation side of things, is quantifying the impact, right? So a trade secret is something of value. There isn't a lot of law right now, although there's starting to be in the US, as to how much value is necessary to have a trade secret. Now, usually most people think it's a lot of value, right? Like it's very high because they're thinking of what, people call, I think it's in Mary's company, the crown jewels, or the Coke formula, right? Mrs. Fields cookie recipe, take your pick. So, but where I've seen issues is as a litigator is that trade secrets, first of all, can develop over many, many years, particularly process trade secrets. And I see that's often a place where companies may patent something specific about the product being made with the process. And typically, from what I've seen when looking at R&D budgets and the investment that goes into making a certain product, again, it's done by the product sometimes. It's, that's how, when you think about where, these people work in our R&D department, and so we're going to assign that there. But what I need to do in a litigation, especially if we're dealing things like negative know-how or like this vendor cut the delivery time, I need to try to quantify that, because trade secret litigation can be very, very expensive, and it can be very, very difficult to prove damages. You can get, and unfortunately, I've seen situations where, believe it or not, just happened here in the Ford case, courts are not granting injunctions as often as I think they should be. They're like, well, they already have the trade secret and they're not going to disclose it to anybody. They're just, kind of maybe going to keep using it. So it's okay. You don't really need an injunction. Hello. And maybe in that situation, the conclusion is you're going to get a forward-facing royalty. I mean, it depends. There's trade secret damages can be all sorts of things, at least in this country. So, you hear a lot about head start damages. You can maybe get disgorgement of profits. So what I have seen, for example, is I had a process trade secret case where the trade secrets were developed over 30 years. How do I know this? Because they had every one of the machines that did the process still. I don't know why. Some were being used, some weren't. And it went from a very manual, this particular product went from a manual process where they had some machinery to a fully automated, it was injection molding. So fully automated, from plastic pellets to putting it in the box. And, we were able to see and document how, from over these periods of decades, things evolved. And why did I have to go look at the machines? Because the entire engineering team left and went and started a competitor. So I didn't have anybody who could tell me. I was dealing with a line guy who barely knew what he was doing. And, was like, well, this was first. A sales guy who knew a little bit, and then machinery. So we had to kind of deduce it from the machinery. But so that was hard. But what was even harder was trying to figure out the investment value. Where did we save money? How much time did we put into this particular innovation? Here's the even more fun part. Not only was the financial data not available or not arranged in a fashion that we needed it, some of it was in really our old archives, old systems that were from like the 80s, and we couldn't even necessarily get into the computers. So one of the things that I offer as an add-on, which is not as commonly talked about, but when I'm counseling clients on trade secrets, is not only think about what are your trade secrets and what do you need to protect, but also document the value, right? Document that, oh, this enabled us to cut our delivery time in half, or, oh, this reduced errors by X percentage. provide data that your litigator down the road will go, thank you, we have what we need, and we can show what the value was. And again, that's also going to be important because I've spoken with valuation firms, accountants and others who do valuation of trade secrets here for balance sheets or any other purpose. And they're like, yeah, I don't have anything. I know what the trade secrets are, but I don't have anything that proves the value. So it's useful in all different ways. And again, needs a lot of thinking, and oftentimes needs work with an attorney who knows trade secrets to be able to say, no, that's real value. Like there's value there in these changes.
Yeah, Eleni, please, you want to add something? By the way, we have so many questions prepared, but the two of you are just like knocking them off. So thank you so much. Eleni, go for it.
I think that what Nicole just said about value is so important. I think that if companies take a time, some attention to why it is valuable, and Mary, I see your comment. Sure, I was going to suggest it myself. I think that it'll be very useful not only for litigation purposes but for context. So if someone from the company has this, catalog, innovation catalog, and they see what the assets are in a high level, and they know why is it a valuable trade secret, it provides a lot of context to understanding why they're valuable. And any person walking into a company and understanding that, it can be very useful for valuation. I mean, I have a different question for you, Nicole, about valuation, but I think it's a perfect point to let Mary Guzman say her comment about valuation.
Yeah, go
Mary?
for it. Please, Mary.
Thank you so much. I just wanted to quickly add that that's one of the things that we have to do for insurance purposes, right? Is for the first time ever, we're sort of trying to assign a predetermined value of a trade secret so that we can schedule it on an insurance policy as though it's a tangible asset. So the valuation part of it's really important to us because without value, it's not a trade secret. I've had a lot of people say that they, collect millions of personally identifiable records and all kinds of data that makes their company really valuable. Well, perhaps it does, but it's what you do with that data that you've made it into a financial algorithm that helps you make decisions that make your company different and more valuable than your competitor. It's that process or the algorithm that you've designed from the data that's valuable, not the data itself. The data itself is not a trade secret, number one. Number two, the thing that I posted this morning actually is very timely that we're talking about this, about the SEC cybersecurity law that just went into effect. Specifically talks about if there is a breach, and Nicole is absolutely right, 85 or 90% of the time it's former employees that take information with them that cause the misappropriation of trade secrets, not hackers. But in cybersecurity law and in all the cyber policies out there, basically, they include the theft of information using a thumb drive or a personal computer or emailing to your home. Those are all things that are considered intrusions into a network, which is a cybersecurity breach. So now it's dragging in what former employees are doing to this requirement under the SEC, potentially, this is my interpretation, to notify people of this material theft. And the definition of materiality in the cybersecurity rule that just came out for every public company in the US, they specifically call out as examples of materiality, whether the asset or assets that are compromised during a breach can cause damage to your reputation or damage to your competitiveness in the market, which is what a trade secret is. So if you don't know what they are and you don't know, at least relative to your other assets, how valuable they are, you're not going to be able to meet the requirement to then issue an 8K or do any of those things when you have a breach that involves something that could be a trade secret. So all of this speaks to the trends that you guys are talking about today about the importance of identifying and potentially valuing, at least in relative terms, trade secrets before something happens to them. Companies just have to do this now. To me, there's just no question about it.
Mary's so right. And I wanted to not forget two things. One, picking up on, the importance of doing all this, and depending on the size of the company, it can be challenging. There are several different software tools out there. One that I found particularly interesting is from a newer company in the market called Tangibly, because they actually, I know for a fact, I've seen the demo from the developer, which she's Israeli. They actually track sharing, and they use AI and other tools to even help identify and, the trade secrets within the company. And so, especially for a larger company, I haven't had experience in operation. I've seen a demo, but especially for some companies, it really can be a super expensive task to try to capture everything. And then I always worry about those exit points, and shouldn't there be something that popped? For years I was like, it would be great if we had something that would pop up and say, did you really want to email that outside the company? And sure enough, they're implementing that, and there are other companies too, but this is, there are some companies who are actually doing, even just the indexing, providing an index long before, people were interested. So this is an emerging market, and I'm sure that there's going to be more tools out there. And of course, insurance, which is new. And so I'd say within the last 5 years, we're starting to see more tools and, other ways of protecting your stuff beyond simply a management process. And then the other thing I wanted to say, and I promised David that we would say this, I want to come back to patents, and not only patents. I also want to talk for a second about, copyright, trade dress, even branding. If the way that I approach, and I think this is similar to what other things have been said, the way that I think about intellectual property and the way that I think about how to protect intellectual property, and I look at it with a little I, a little P, right? It's really broad. Could it include confidential information? Sure. I don't know. That's a whole other topic. But the way I look at it, it's not an either or. It's not we're going to have patents or trade secrets, or we're going to get a copyright on our code, or we're going to keep it as a trade secret, right? It's really all of the above. And you may not be able to do all the things all at the same time. I mean, you've got to prioritize, and that's why it's really important to work with attorneys who can help you do that. And it's not a one size fits all answer either, because, maybe you have a process. David and I actually had someone we talked to who had a process that they could have kept trade secret, but that wasn't their business model. Their business model was they wanted to be able to have a decentralized operation of the trade secret in the marketplace. Well, I was like, okay, no, we got to talk to David, because you need to get a patent if you can, because at least on some part of it, because that's going to be a recipe for disaster, trying to keep, 50 different, 100 different people who are using your trade secret confidential. Yeah, no, that doesn't work. So it's a web of protection. I always talk of it that way. And it's the other thing, it's not one and done. Like, you're especially with trade secrets, because those are being created sometimes every day. It's something you have to really stay on top of, and really need to, be sure that you're doing it right. And the other thing related to that, when it comes to secrecy, you could have done everything right vis-a-vis that one person that did take your stuff, right? You could have a great agreement with them. You could have followed up. You could have trained them. But here's the fun part from discovery. I get to go ask about the 20 other people who didn't take your stuff. Did you have all those protections correct there? And as somebody who may have done something bad, I'm going to be looking to point fingers like, you really didn't take the reasonable precautions. Okay, fine. You had an agreement with me, but you let everybody and their grandmother have access to the stuff without having agreements. And again, that goes back like 30 years, right? It's not, and I've seen investment firms not do adequate diligence to see, okay, you have this now, you have people sign into the plant now. What were you doing 5 years ago? What were you doing 10 years ago? Do you even know?
No, that's an excellent point, Nicole. How many times have we've all spoken to companies that are talking to investors? We know that not every investor is going to sign an NDA. So, everybody's betting that they're going to sign the NDA, but they end up not signing the NDA. And that's the one break in the chain that if you're trying to now show that an employee stole it from you, well, you didn't keep it a secret with anybody, really. And so, yeah, that's a big, big pitfall for sure. Frankie has a good question. I think it's a good one. Can I license a trade secret? Right? I'm doing everything in my power to kind of keep this confidential. Everybody's locked down for the last 30 years. Can I license my trade secret? What do you think?
Yes.
Yeah.
I don't know if you should, but
Right,
yes,
that's
you can.
It's risky.
Risky for sure. Risky for sure, for sure. And what about the reverse of the situation? I think I get this. We hear this all the time. Like, okay, I know that if I'm keeping something a trade secret, I know that I can only go after someone if they misappropriate it. Okay, so I'm going to not do the trade secret. I'm going to go for a patent. Now I have the patent. I got my investment. Now I believe that there's a third party that I believe might be infringing my patent. They're claiming that it's a trade secret the way they're doing it. How does that mechanics work? What can I do as a company that has a patent? Can I go after this company?
A lot of it's timing. I've never seen, there is a statutory carve out available in the US. I don't think I've ever seen anyone actually take advantage of it because it requires you to put things out there that you might not want to put out your trade secret. And especially then the issue in those cases, it says like if you were doing this previously as a trade secret, you might be able to avoid infringement. But that has a lot of problems in actuality.
Yeah.
Because oftentimes, more often you want to say, no, I don't infringe, or no, your thing's not valid. And you're putting your trade secrets at risk because you're putting them out there
Right.
by saying that you did it before. So the practical reality is that that's often, even though theoretically that's available, a lot of companies don't want to use that as their first line of defense. And it's hard. Timing's often a hard one to prove too. Like, how long have you really been doing it?
Yeah. Eleni, you want to comment on that a little bit?
I'm interested in what Nicole just said. So if I understand correctly, Nicole, by US law or US companies that are sued or potentially can be sued for patent infringement, and they have this defense that they have a trade secret that they have maintained, you're saying they don't always want to use this line of defense because using it means they have to reveal the trade secret. They need
and
to
also essentially you're saying, I'm doing this thing. I just was doing it earlier.
I just did it before you. Right.
I've talked about this with companies, and it's actually, I think it's a fairly new, I forget when it came into effect. It's not been around that long.
Right.
It's just not, I'm not sure that would be my first line of defense, honestly, in a patent case, if I could avoid it. I mean, you might have to, but.
Yeah.
So yeah, I think we're talking about
solid advice.
Yeah, I mean, we're talking about prior user rights and stuff like that, but that's probably for a whole nother session. Just in the interest of time, because we've talked about a lot, just some kind of like do's, don'ts, mistakes that you've seen, Eleni, like you can kind of impart people with some takeaways, things they should be doing. Yeah, or mistakes people made.
I think that the biggest mistake is not realize that you actually have a lot of trade secret. And what happens from this mistake is that you don't protect the information. If you don't know that you have it, you don't protect it. When you don't protect it, you can't communicate to your contractors, employees, what to do and what not to do. You can't have a policy. And then when you're not aware, you can present it to your investors. So you know what? Another mistake that we haven't touched about is companies work on patents and they decide to leave out of the patent stuff that they think is a trade secret. And intuitively, they think that if it's not in the patent, then it's protected, and they just leave it, and that's it. And it's a trade secret. And if someone took it, they would not even know. So we see all these people in companies that they sign this 20-page employment agreement. 3 pages are IP, 2 pages are trade secret misappropriation. They sign it not even knowing what it means because no one explains to them what it means. So that's mistakes. That's a big one. yeah, basically not being aware of trade secrets in the company, that every company has them, and out of lack of awareness, that it's like a waterfall of all the rest of the mistakes, I think.
I agree. I mean, I definitely think there's this connotation that it's easy to keep something secret. I just don't have to talk about it, even in life, right? But that's not really the case, right, Nicole? I mean, what do you think? Mistakes, do's, don'ts?
Oh my gosh, there are so many. I'm a litigator. But I would say two that I would mention there. It's not that they're the biggest mistakes, but one that I've seen come up quite a bit is where companies are patenting. I do think that it's extraordinarily important to also converse with your patent attorney, who may be in a larger context, not the one counseling you on trade secrets, or maybe you haven't thought about it yet. But, and not all patent attorneys talk about trade secrets. David's very forward thinking in that. A lot of patent attorneys are still like, what is patents?
Yeah,
It's all about patents.
totally.
But I have seen a number of cases where, in publication, not saying my clients necessarily, but where a company is put stuff in a specification in the background that's actually revealing a trade, what they then think of as a trade secret. Was it necessary? Was it not necessary? I don't know. But here's the big risk, right? If it's something that's valuable and you put it in the specification, but it's not in the claims. Now, this may have been just something that happened over the course of, prosecution, that it got excluded from the claims potentially, but that's not usually the ones I've seen. Usually it's just in there. And so I would say, make sure that when you're working with a patent attorney, if that patent attorney hasn't talked to you about trade secrets, that you're being very careful to talk with them about, does this have to go in? This is something that's very important to us, that, if we're not going to put it in the claim or can't put it in the claim, for instance, like, who's the one supplier of your particular, important component? That I've seen cause people issues later. And the other thing I would say is there's something that I hadn't seen, probably because it hadn't been as much of a thing recently. Someone I was dealing with in settling something asked for a residuals clause. And I hadn't heard of that because I knew it by the old name, which here called an unaided memory clause. And I hate them no matter what you call it. And actually I'm talking about this on my blog this month that just came out, but where it says that we have to keep things confidential unless we kept them in our head. Some places that's fine if there is a jurisdiction that requires you to document your trade secret to be able to enforce it. However, most places in the US, I think really everywhere, I don't know, I can't say I've been in every single state. It's okay if it's in your head. That can still be something you're not supposed to use. So why would you give that up? And so as an IP lawyer, trade secret lawyer, I'm a hard no on that. A lot of private equity firms want that because they're looking at different people in the same industry. But if you're gonna have it, again, do everything you can not to. But if you're gonna have it, try to put in some protections, like things like carve out trade secrets, or, you're going to need to make sure that you get back everything, notes, emails, everything that could help their unaided memory, so it's a really bad trap. So that goes back to what I was saying earlier. NDAs are a minefield. You got to have them, but you got to have a good one. And people just reflexively, especially with investors, like, oh yeah, I'm going to say that'll be great. Or big companies they want to partner with, and it's their form. This is our form. You have to take it. Ooh, can be really bad down the road.
Yeah, good points. Does anybody want to ask any? We're almost at time. We're a little bit over time. Anybody want to ask any questions live? This is your opportunity. I know Nicole has been great with and has been looking at the chat, so thank you for that. Wendy, what is your question? We'll unmute you. Sorry about that. Wendy, go for it.
Oh, can you hear me?
Yes, we can hear you.
I think I've been relying a lot on the unaided memory thing. And also I keep all my computers are all offline. I have nothing connected to the internet at all. But because I'm kind of new to this. So I'm wondering, do you think it's good enough to have offline computers? And I keep almost no notes and I don't talk to hardly anybody ever about anything, but I'm just wondering because I'm kind of new. I mean, I don't
are
have
you
a
worried
company.
about your information or what you're learning from
I'm
other
worried
people?
about, I'm worried about the information that I have that I worked a long time on. And so I guess I'm worried about the whole process, you know, but as I said, I'm just beginning.
Yeah, so
I mean, I don't have a patent yet, is what I mean.
yeah, so Nicole, you didn't hear Wendy's intro, but she's working on something that potentially might be patentable. And I guess the question is more about her fear with sharing that information. Maybe not with a patent attorney, right? Because there's attorney-client privilege, but maybe with other providers now. I guess her question is it best practices to keep that stuff, off of computers, only in her head? But then I guess the question is how does she then share that knowledge to get the actual product or service?
Yeah, I mean,
Yeah.
I honestly don't think that's realistic in a commercial context. Unless you can really, I do know some people who have made the choice. Somebody I know who's got an ice cream company that does alcohol infused ice cream, and that was something she probably could have gotten a patent on, but was so novel that she kept it internally. I know that in their situation, what she's doing is totally 100% controlling the process, including even like her add-ins and whatnot. Like she's not having anyone manufacture any component or anything, right? Like she's got this very, very big lockdown. I mean, that's a legitimate approach, but I'd say most people don't have the resources, bandwidth, ability to do that. And I mean, honestly, I'd say that's a kind of a shocker for me. Like I've never had a client even try to do that. So if you can and it works for you, that's great. Do you have to? I mean, do you have to have other protections if you're gonna put stuff on the internet, in a cloud, or if you're gonna share information? 100%, like we were just talking about. But is the only answer to just keep nothing in paper, nothing anywhere? I mean, okay, what happens if you get hit by a bus? I don't know.
Right.
That's
Yeah, that's a good point. So Wendy, I hope that helps. Any other questions before we end?
It was
Frank?
a really quick one. Sorry, I just put something in the chat. I was like, what do you do with ex-employees when, they've got shared drives, they've got email accounts, they've got all sorts, and a bit of a headache kind of, and, because in this sort of digital world, we do everything and we share, all the shared drives. I guess if you don't want it accessible to them anymore, but equally, do you have to keep everything somewhere just in case it's used for future? Just on a really practical level.
This is a litigation related question, I think, because
Well,
otherwise
it's actually a technology question, right? I mean, that's something I would talk with your your IT vendor, or if you don't have one, find an IT vendor. And there's lots of different things you can do. I mean, one is you don't allow a BYOD policy. You may not allow people to do certain things. I recently learned, because I actually do have a BYOD policy for my firm, that you can actually get software installed on other people's computers, where it can kind of cabin the stuff, almost make it like its own little computer on a computer. So there's a lot of tools out there that you can use to ensure that you can wipe things. Again, you make choices about, do you want to give them devices? Do you not? There are companies though that they do not allow employees to use the cloud, like we were just talking about. I mean, that's it really all depends on the industry. and the size of the company and what you're comfortable with. There is no one answer, but if you're worrying about it, I 100% would suggest starting with a good IT vendor and kind of working with them on what would make them, as well as an attorney, right? Because you want to have good policies and agreements that you are enforceable and a good process for exiting employees. So it's kind of both things. There's also a lot of tracking that goes on, like you can track large downloads. So there's a ton, especially I know bigger companies, there's like a lot of software that they use to prevent this kind of thing. Some of it's becoming more available for smaller companies. So there's a ton out there. I mean, that's the good news, right? Like there's a lot of
thank you.
resources
Yeah.
available. It's just time consuming to find them and implement them and then stay up with them.
Thank you.
Eleni, you want to add anything to that?
No, I didn't understand what Frankie's concern was to begin with, because there's also privacy considerations and it's it's a tricky
Yeah.
question.
It is a tricky one because you kind of like, and that's where I'm saying that, you kind of, when somebody leaves, you don't want to go into the emails or shared drives just in case they have personal stuff. Do you say before they leave, take anything personal out because we may access it? I just don't know. It's a minefield because there are competing, all of this sort of personal data and things like that. You don't want to be, yeah.
Right, but that's why it's important to talk with people like Eleni and Nicole before, right? So that you kind of set up these policies. Anyway, yes, I think we all have to leave. We went a little over. Thank you, everybody. Thank you, Eleni. Thank you, Nicole. Thank you, everybody,
so much.
attending. We'll send you a recap. We'll send you a video. We'll
Thank
send you
you.
some links. Look out for our next meeting, which will happen in about 4 or 5 weeks. And everybody have a good weekend. Thank you so much. Bye. See you later.
Thank you.